Hello. When you go to court, at least when you go to civil court, one of the most important points in your preparation is collecting evidence. And very often, at least in my practice, people rely on their own testimony as evidence, which is an evidence, of course, yes. But is it as strong as we have a tendency to think? If we can speak of any kind of an informal hierarchy of evidence in civil court. Why informal? Because at the end of the day, it's all up to the judge to decide what evidence the court would believe, the judge would believe, what evidence the judge will not believe, to decide what's credible, what's not credible, what's plausible, what's not plausible. So if at any moment the judge decides that some personal testimony is more credible than some notarial act, well, so be it. But informally, when we prepare a litigation, we can think of some sort of better and not so good evidence, or at least in comparison. And this is what I'm going to discuss with you today. So, what can we see as evidence in court? If some fact, particularly some legal fact, is established by a law or by a government regulation under certain law, then it's a very good evidence. I would include here something already established in some other judgment. Let's say some other judge in some other case already said that the fact is this. For example, it happens when we use the judgments in criminal cases when it comes to a civil case for civil responsibility. But it might be just another judgment where a certain fact was recognized as valid. Then we have notarial acts. Some facts should be necessarily proven by notarial acts, as, for example, immovable property transactions, like real estate transactions. There are some other things like that which are not even valid if there is no notarial act, but sometimes you can go without it. But with a notarial act, your evidence is better. Somewhere around, I would say, we might place minutes of some bailiff's visit, because bailiffs are professional witnesses in this sense, and if some fact is attested by a bailiff in his or her minutes, this is it's a very good evidence, very good proof. Then, if we can speak of any kind of hierarchy, so I do remind you, it's all informal, then we can look into those documents that are produced, let's say, officially, some response from the government, of course, some medical records as they are kept in some hospital or some other establishment, police reports, again, attesting to some facts and to some investigation, photos, but there you will need to prove the origin, like when it was taken, who did take it, and what were the circumstances. Some other recordings, handwritten paper documents, some maybe albums, some publications, and so forth and so forth, as long as they normally prove the existence of themselves or the facts that are mentioned there as registered in a due course of like everyday business or something like that. Then there are expert reports, which are not like 100% bulletproof, and the judge can dismiss an expert report. But the more complicated, technically complicated or professionally complicated the matter, the more the probability that the judge would rely on the explanations given by an expert. But of course, there is a situation when one party has their expert report, another party has their expert report, and there is contradiction, and then the judge might be tempted to dismiss both and just again rely on his or her good judgment and other facts in the case. That's why I put the expert reports point here like so low, because again, the legal fiction, let's put it this way, is that the experts are absolutely impartial and have like scientific or at least like huge professional background to bring up some conclusion as the only possible. But in reality, it's not always like that, and even in a best expert report, it's all about like more probable, less probable, usually at least. Highly probable. Then there are impartial witnesses, eyewitnesses, who personally experienced something, like saw something, heard something. And here, well, the impartial status of a witness, that the witness does not benefit from any result, brings that testimony closer to the judge's ear, let's put it this way. But again, human perception is not very much reliable and very often prone to interpretations and habits and what some person is normally used to notice as opposed to what the person does not notice. And there are a lot of situations when a person observed something but didn't pay much attention, later restored in his own memory using his or her own imagination as it should have been, and then like honestly believing that how it was, presented this testimony to a court. This is why even the impartial witnesses are not that much reliable, especially if we have a notarial act and some particular document or some particular registration of the events as they happen, from some cameras, for example, or surveillance, whatever. And as you can see, only the last, and I would say in reality least credible, is the party's testimony. So if you rely this much on your own testimony, it might be either because you did not prepare yourself well, or it's because your case like sorely lacks of any real evidence, and therefore you have to rely only on your ability to convince people around. Again, as I mentioned before, it's not something official. It's more or less a perception of a reality as I can bring it to you. And the conclusion that I'm trying to prove by that is that even if you're 100% sure in your case, even if you think that everybody knows and that there is absolutely no other explanation, and that commonsensically you're just completely right, still spend some time and effort and find better evidence than that. Find impartial witnesses, find experts if necessary, find by all means direct documentary evidence if there might be anything. If there are notarial acts, and if they are not in your favor, consider twice if you really want to go against them. And of course, if there is a legal document against you, that might be really hard. This is what I wanted to tell you about this informal hierarchy of evidence. Thank you and have a nice day.